After the rather momentous Supreme Court judgment this morning, I thought I would explain just a little bit of the basic background to the hearing this morning and, of course, the outcome for those of you that might be interested. First and foremost, a little bit of a history lesson. If we go back to 1689, there was such a thing called the Bill of Rights, and the Bill of Rights was introduced with William and Mary coming back as monarchs after Cromwell had taken over. The deal, as it was then, was that the monarchy should no longer be ruling the country through what was called the divine right of kings. In other words, the monarch was there on earth as God's representative and could do no wrong, literally, and was above the law, of course. So the Bill of Rights made it very clear that there was what was known as, or what became known as, the separation of powers. Now, the separation of powers means that there is an executive, there is a judiciary, and there is a legislature. And all three of those are meant to work together, but also to act as checks and balances for each other. The executive means essentially the government ministers from the Prime Minister downwards through the Home Secretary, etc. The judiciary are obviously the judges, right the way through to the Supreme Court judges, as we saw this morning, and the legislature are essentially the two chambers of the House of Commons, the House of Lords, with also the monarch at the helm giving nominally royal assent to any legislation that goes through. Of course, it is only nominal. The Queen, the monarch, as we, I'm sure, know, has very little power in terms of political or legal. What that means is that actually when an Act of Parliament goes through Parliament, royal assent is actually given by a Minister of Justice, for example, or the Minister of Justice. So there is this separation of power. Now, what that means is that if a government is elected, that government is not able generally to make the law or change the law. That would lead us to a situation, for example, where you have a government and government ministers, the cabinet, for example, the Prime Minister, the Home Secretary, simply deciding to create or change law in this country without proper parliamentary scrutiny. It's the legislature that is meant to make the law, and the legislature means Parliament. What that means, of course, in terms of this morning's decision, is simply that Parliament are the only ones that can make or change the law. The judge's role, the legislature, is to act as an interpreter, if you like, of that law, whether that be incrementally developing case law or interpreting acts of Parliament. And what they did this morning with Lord Neuberger at the helm, of course, was to interpret acts of Parliament such as the European Communities Act, the EC Act of 1972, which took us into the European Union, the European Economic Community as it was then. The real issue with this whole case is that what Theresa May wanted to do was simply trigger Article 50. And that, she said, would take us out of the European Union, or begin the process of taking us out of the European Union. The problem with that, for anyone with half a brain, is simply that that would mean laws change. All of the laws that come from the European Union that are part of English law would change. Many, if not all of us, would lose our rights under EU law, and there are many, many, many rights. Employment rights, to name but one. All the directives, equal treatment, legislation to do with discrimination, to do with workers' rights, all of that would, at least in theory, be lost. Yes, it can be replaced, but it would still be lost. And the only people that can actually make that decision are Parliament. The parliamentarians, the MPs in the House of Commons, House of Lords, need to vote on that kind of thing. We elect those MPs, at least in the House of Commons, and as the first level of the legislature, we put them there to do exactly that. So the idea, the very idea, that Theresa May and her government could actually trigger Article 50 was really nonsense right the way through, as was suggested by Neuberger. As Neuberger said this morning, it simply goes against hundreds and hundreds and hundreds of years of our constitutional principles and how the law is made in this country. So, an absolutely no-brainer, really. As Keir Starmer said this morning, the really awful part of all of this, I think, is the money that it's cost in appealing this. Really, the government, Theresa May, should have taken the High Court decision and run with it, had the courage of their convictions to go to Parliament straight away. If people like Farage are arguing that this is all delaying tactics, the only one that's really delayed all of this, or the only people that have really delayed this, are the government. They should really have gone straight to Parliament after the High Court decision, instead of waiting for 3 long months for this Supreme Court decision this morning, which was inevitable. 8-3. If that's a football match, that's an absolute thrashing. So essentially, that's where we are. It's all to do with this idea of separation of power. This is not to do with whether we should or shouldn't leave the EU. Everyone has their own view on that, of course. But ultimately, the Supreme Court pointed out very clearly this morning, very clearly, as did the High Court, that a government cannot just make or break or change the law. Years and years and hundreds of years of case law, of cases coming before the courts, support that. And really it was an absolute no-brainer. It means a change in the law, and if it means a change in the law, government cannot use what are known as these prerogative powers. Now, of course, prerogative powers do go back to the days when the monarch could make decisions affecting the country unilaterally on their own. Those prerogative powers over the years were given over mainly to the executive, and that's what Theresa May was arguing. Given over to the executive to use those prerogative powers in ways that they see fit. And there are still those prerogative powers that ministers still have. For example, the prerogative power used to be the royal pardon. I'm sure many of you might be familiar with the royal pardon. But the royal pardon is now, again, given by, essentially, the Minister of Justice, or the Home Secretary, essentially. So what that means, really, is there are certain prerogative powers that do exist, but lawmaking is not one of those prerogative powers. Since William and Mary, since we lost this divine right of kings with James I and Charles I, hundreds and hundreds of years ago after Cromwell, the monarch or the executive have never had those prerogative powers simply to make or change the law. Only Parliament. It's called parliamentary supremacy. So really, all in all, that was the outcome today. It's now down to the MPs to vote, to decide not how we leave, but if we leave. What really rankles, I think, over the last few months is all of this talk by government, by Theresa May, by David Davis, and by the press, almost making out that this was a done deal right the way through from last year. People woke up on the day after the referendum seriously believing that we had left the EU, and that says it all. As I'm sure you might be aware, there were more Google hits from outside that were from inside, I should say, the UK the day after the referendum on what is the EU than there ever had been before, which I think says it all. So the misinformation is really what has been so criminal here. But it's a good day for the rule of law, for sure. The rule of law has been restated by Neuberger and the Supreme Court. And thank goodness for that. Thank goodness we live in a country where there are these checks and balances, where Your government can't just do whatever they please. That essentially is a dictatorship, and that is really the positive thing that's come out of this morning. So I hope that has been useful, maybe informative, but I thought I would give a brief breakdown over what has happened this morning on such a momentous day.